Acceptance. When you accept for value, you are accepting whatever consideration the United States has offered to you as evidence of an obligation it has to you as a beneficiary, as well as whatever consideration is offered on the instrument that is being transferred to you through the U.S. citizen you represent. The United States is humbling itself by asking you to give it assistance. It is applying for credit on every instrument that is issued or transferred for value. If you just receive one of these instruments without accepting it for value and returning it for value, the presumption is that you intend to pay it. If you pay it with a check or you can pay it with your prepaid account, it is up to you. But you have to pay it immediately. 72 hours per commerce. You've got 72 hours plus 3 days grace. 3 days grace means that you got it in the mail within 72 hours, and then they got the 3-day grace because they figure that the United States Postal Service will have it to its destination in 3 days. They will be making the assessment on whether or not you conform to the rules and got it done in 72 hours by the United States Postal Service stamp that will be placed on it after you put a stamp on the envelope. They will round bop stamp it, and it'll say the date, the time, and the location that it was mailed out at, all right? And that's how they prove that you're compliant in being expeditious about taking care of these obligations on behalf of the United States. But you have to pay it immediately, or you will be deemed to be in dishonor. Everything about what we're doing is all about always remaining in honor, okay? If you have acceptance for value, you can use a distribution from the trust to pay the instrument. If you just retain it or argue about the existence or amount of the request, you will pay it with a check, tangible property, or your body. Did the United States offer a birth certificate to you? Did you receive it? Did you accept it and acknowledge it for value and return it as a security? If you do not accept it for value and deposit it as an asset, you have voluntarily waived rights to a distribution that is available to you. In a purely commercial system, rights are remedies. Parties to a modern commercial transaction need remedies in the event one of them breaches the terms of the agreement. The birth certificate is a remedy and represents an antecedent claim you have against the United States. It is also evidence of a pre-existing contract. It represents the prepaid account you have available to you for set-offs. Acceptance is an agreement and leads to a binding contract. If you do not set the terms of that binding contract, the United States will. Acceptance by silence. Acceptance of an offer, not by explicit word, but through the lack of an offeree's response in circumstances in which the relationship between the offerer and the offeree justifies both the offerer's expectations of a reply and the offerer's reasonable conclusion that the lack of one signals acceptance. Ordinarily, silence does not give rise to an acceptance of an offer, but this exception arises when the offeree has a duty to speak. Black's Law, 7th edition. If an offeree has a duty to speak through an existing relationship, his silence is acceptance. Because of a presumption of the existence of a relationship, the offerer has a right to expect a reply from the offeree. When you send communication to officers of the United States, you are basing them on your presumption that they have a duty to respond. They do not respond based on their presumption that they are not required to respond, because you are presumed to also be an employee of the United States. When they send communication to you, they are basing them on their presumption that you have a duty to respond because you are the one representing that employee of the United States. You generally do not respond properly based upon your presumption that you are not required to respond. This is all a matter of perspective. So, under the doctrine of idiom sonum, if things look the same, sound the same, they are the same. So that's another presumption and assumption they're operating off of as well. If you are acting like a U.S. citizen when you send your communications, they do not have to respond, and their silence is not acceptance. If you are acting like one of the people who are beneficiaries on the trust established by the Constitution and by President Roosevelt, they do have a duty to respond, and their silence is acceptance of the terms of the offer you make in your communication. A man can refuse to approve the application for credit inherent in instruments issued for value by the United States, but that might imply the man is an enemy of the United States. That is not good. It might be better for the man to approve these credit applications through acceptance for value and return for value by signing and processing them properly. The man can avoid a trading with the enemy charge and at the same time fulfill a presumed moral obligation to aid and assist the United States in its time of emergency. Since 1933, the people have had a means by which they can have everything they want as beneficiaries of a trust created by President Roosevelt. Acceptance for value is a means by which the people can earn that beneficial position if they want to. They are not required to earn it, but they can if they want to. That is a personal choice. Offer and acceptance and counteroffer. To form a binding contract with the United States through offer and acceptance, someone must initiate the negotiation. Either they will initiate it or you will. The one who makes the offer is humbling himself and honoring the other party through the offer of something as consideration for the purpose of getting consideration from the other party. Consideration can be money, interest in property, or performance, energy, or anything that will support a simple contract. In modern commercial transactions, gold, silver, and things are not value, but promises can be value. Interest in things is value. The consideration on both sides must be equal for the transaction to be balanced. Value on one side equals value on the other side. Your communication can establish by your action, not your words, that you are one of the people. It should contain the instrument that was issued and transferred to you for value. After you have accepted it for value, it should say what consideration you are offering, acceptance for value instrument, and what you are requesting as consideration in return. Set off equals distribution from the trust. Public and private do not mix. So a request for a distribution from the trust would be like asking I'm not even sure I'm sure that's a misspelling there. The public does not know anything about a distribution from the trust, but it does know about set-off and securities and entitlement holders, etc. Your communication could contain or should contain the terms of an arrangement or agreement that will be a win-win situation. It should ask them to do something responsive to you as one of the people, not as a U.S. citizen. But it cannot contain too much truth. It should not contain anything that connects you to benefits granted by the United States. Those benefits might be use of the United States statutes, use of the United States courts, use of the United States judges, opinions, use of the United States currency, use of the United States license, use of the United States officers, use of the United States civil rights, use of the United States rules and regulations, use of the United States forms, use of the United States bonds, or use of the United States insurance, to name a few. Since 1933, American common law is not available to the people through the courts, but commercial remedies are available through the post office. Your communication should not contain anything that draws from common law remedies. The commercial remedies contain the principle of the common law that is needed to settle the account. The only system of commercial remedy available now is the law of nations, which is based on agreement using the law of merchant. United States courts enforce agreements using the law of merchant. You have the power to negotiate agreements that are advantages to you, or you can let the United States set the terms of the agreement. That is a personal choice. Your communication should state the terms of the agreement you are offering to the other party, who must have a delegation of authority, warrant of attorney, power of attorney to represent the United States. Your communication should be direct to someone who is authorized to bind the United States. Low-level employees of a corporation generally are not authorized to bind the corporation they represent. Just as low-level employees of the United States are not authorized to bind the United States. The president can bind the United States, and he has first-level agents who have the delegation of authority to do that on his behalf. That would also be known as the alien property custodian, who was in that position, was then moved to all 50 attorney generals in the United States. They are the heads of at least 3 of the executive departments of Homeland Security, Legislative Department of the Treasury, Executive, and Department of Justice, Judicial. This is a mini government within a government corporation. It governs under military rules and doctrines, the law of occupation, using Admiralty courts, Article 1, Section 8, that implement the law merchant to satisfy the claims creditors have against debtors. Look for the Department of Homeland Security, flag of jurisdiction at border crossing. It has a dark blue background with a circular seal of the department in the center. Since none of the members of the legislature or executive and judicial officers of the United States has the oath required by Article 6 of the Constitution, the only way they would have a duty to you is through the oath of the president. The executive trustee on the trust created by the Constitution and the trust created by Franklin Delano Roosevelt, his position as president, Article 2, Section 1, comes in the Constitution before his position as commander-in-chief, Article 2, Section 2. His oath is required in Section 1, not Section 2. If you act like a surety for the United States instead of a beneficiary of the trust, his officers have no duty to speak, and their silence is not acceptance. If you act like a surety for the United States, you have a duty to speak, and your silence is considered to be acceptance. When the United States targets you to give it a loan, you can 1. Not respond immediately and pay later, 2. Refuse the instrument because it is defective, or 3. Use your set-off as a distribution from the trust. You cannot use the set-off if you are holding the birth certificate in a filing cabinet. If all you have done is taken the birth certificate and have not performed when asked to pay, you have waived your beneficial interest in the trust and have agreed to be liable as surety. That is a personal choice. Acceptance for value equals taken for value. Issuing an instrument is not the same as issuing an instrument for value. Accepting an instrument is not the same as accepting an instrument for value. Generally, the issuer of an instrument is the one who has the duty to pay. If an instrument is issued for value, it appears its issuer is not actually a person entitled to enforce it, and may not even be a holder in due course of another enforceable instrument. He has no standing to demand payment or performance, but by issuing an instrument for value, he might be able to open a new account through a transferee's unqualified taking of the instrument. If the issuer can get the transferee to take the instrument with no conditions on the taking, the transferee is waiving the defects in the instrument he is taking. The main defect is that there is no consideration attached to the offer to contract. There is no value in it at that point it is issued. The issuer is looking for the transferee to provide the value. The issuer is looking for the transferee to provide the consideration for both sides of the transaction. By merely accepting the instrument, the transferee becomes an accommodation party. He receives no rights, no defenses, and no value for his agreement to lend his name and his credit to the transaction. He does not realize that there is a hidden value in the instrument that he can use to his advantage if he accepts it for value and returns it. If the issuer succeeds in creating a new account agreement with the transferee, he might later be able to close that account through a forced payment or collection through a penal action in an administrative proceeding. The issuer has defenses if he issues the instrument for value that he would not have if he had just issued the instrument. He has no authority to issue the instrument, so he has to issue it for value. He is giving a subtle notice by issuing it for value that the transferee has no legal duty to pay or to contract. If the issuer were entitled to enforce the instrument, his instrument would refer to a pre-existing contract in detail. Since the pre-existing contract presumed to support this new simple contract is the application for the birth certificate, or a pledge of allegiance to the United States, or an application for a social security number, or an application for any number of other benefits granted by the United States, the new instrument must be issued for value. If he issues it referring to a non-existent contract as its basis, he would not have defense. He would be acting outside his delegation of authority. It appears for value may be translated into to get value or to get consideration. Example, the child acted out for attention, i.e., to get attention. The man worked for money, i.e., to get money. The issuer issues the instrument for value, i.e., to get value. Black's Law 4th edition definition indicate another word for acceptance is taking. Acceptance, the taking and receiving of anything in good part, and as it were, a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. Black's Law 4th edition. Acceptance is tricky. No one is required to contract if he does not want to, since there is a presumption that every man has previously agreed expressly or tacitly to be a surety for the United States. A naked acceptance appears to recognize that preceding act, whether it actually exists or not. The presumption can be defeated or avoided by not accepting or taking the offer. Not accepting is also tricky. If the presumption of suretyship is allowed to stand unrebutted, non-acceptance becomes acceptance. Acceptance puts the liability on the surety. A rebuttal must be through action, not words. Acceptance for value and return for value is a rebuttal that overcomes the presumption. Refused for cause without dishonor does not overcome the presumption, but it does address defects in the instrument. If an instrument is refused for cause, it must address the right points, or the communication will be seen as dishonor. It is an option, but it requires more understanding of statutes and rules of the court than most people want to learn. In 1966, the Oklahoma Supreme Court explained the importance of applying necessary elements to confirm that an instrument has been taken for value. The first requirement is that the instrument be taken for value. It is clear that the defendant's check were taken by the plaintiff for value. UCC Section 3-303 provides that a holder takes for value when it acquires a security interest in the instrument otherwise than by legal process. In this analysis of the evidence, we have concluded that under the Commercial Code Supra in Oklahoma, the plaintiff took the check for value as a matter of law. The jury should have been instructed as to each of these elements and should have been advised that the plaintiff had satisfied the first elements of taking for value. Some of the instructions given by the court indicated that taking for value was an issue, and the instructions went further and stated that the bank would be taken for value. that the bank would be taken for value to the extent it had a security interest in the check. The element of taking for value was very marital to the plaintiff's case, very material to the plaintiff's case. People's Bank of Aurora versus HAR, HAAR, 421, page 2D, 817, 1966. This case was about negotiable instruments, so Article 3 of the Commercial Code controls the meaning of value. General definitions of value in Article 1 does not apply generally to Article 3 negotiable instruments. A negotiable instrument can be a promise, a note, a promissory note, signed by a maker, or it can be an order paper paid to the order of or paid to the bearer, a draft signed by a drawer. The person who is entitled to enforce the instrument is the one who decides if it is a promise or an order, unless its terms require it to be one or the other. This is a personal choice. UCC 3-104, negotiable instruments, E. An instrument is a note, promissory note, if it is a promise, and is a draft if it is an order. If an instrument falls within the definitions of both note and draft, a person entitled to enforce the instrument may treat it as either. UCC 3-103, definitions. A. In this chapter 3, drawer means a person who signs or is identified in a draft as a person over ordering payment. 5. Maker means a person who signs or is identified in a note as a person undertaking to pay. The Oklahoma court referred to the Oklahoma Commercial Code as its source for determining if the check had been taken for value. As with the general definitions of value given at UCC 1-20144, the Commercial Code of the Commercial Code, it will require close scrutiny to understand the various applications of UCC 3-303. A basic principle of natural order of things is that contracts are not valid if consideration is lacking. Before 1933, gold and silver, things, and promises of performance energy were consideration. Consideration was and still is anything sufficient to support a simple contract. A simple contract does not have to be written, but can be. If a contract is written and is not under seal, it is generally a simple contract. A contract under seal is not a simple contract. A signature is not required on a simple contract. If you take gold, silver, and things away from the list of what is consideration, the only thing left to be consideration for a modern-day contract is a promise. UCC 3-303, official comment. The distinction between value and consideration in Article 3 is a very fine one. Whether an instrument is taken for value is relevant to the issue of whether a holder is a holder in due course. If an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. Consideration is defined in subsection B as any consideration sufficient to support a simple contract. The definition of value in sections UCC 1-20144, which doesn't apply to Article 3, includes any consideration sufficient to support a simple contract. Thus, outside of Article 3, anything that is consideration is also value. A different rule applies in Article 3, subsection B of the Uniform Commercial Code, section 3 hyphen 303 or Uniform Commercial Code 3, subsection 303, states that if an instrument is issued for value, it is also issued for consideration. The official comment says, if an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. The reverse of that statement is, if an instrument is issued for consideration, the issuer has no defense to the obligation to pay the instrument. Articles 1, 2, 4, 5, 6, 7, 8, 9, value equals consideration. Article 3, issued for value equals issued for consideration. The issuer on a demand for the United States is acting as an agent of the United States. The issuer on such an instrument is the United States. If the United States issues an instrument for value, the United States has no defense to the obligation to pay the instrument. That only applies, however, if the transferee properly endorses the instrument and returns it to the issuer. The banker for the United States is the Secretary of Treasury. He or his agents should receive the endorsed and returned instrument. At that point, it is treated like a check and can be deposited to settle an account in the accrual bookkeeping system. Acceptance and acceptance for value are not the same thing. Accepting an instrument without a qualified endorsement waives all defects there may be in the instrument, including the value or lack of value that comes with it. Remember, the official comments for Uniform Commercial Code 3, subsection 303 says, if an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. The reverse of that statement is, if an instrument is issued for consideration, the issuer has no defense to the obligation to pay the instrument. If there is no value to support a demand instrument, it has to be issued to get value. A general acceptance of such an instrument successfully transfers the liability the instrument carries to the acceptor, even if there is no value in the instrument for the acceptor to rely on. The acceptor is still liable. He has no defense. He must pay it himself. Is he going to pay it with a check or pay it with his prepaid account? If the acceptor can see that the value is the commitment of the issuer to pay the instrument, then there is value in the instrument, as long as the instrument is accepted for value. Accepting an instrument for value and returning it is notice to the issuer that the endorser is not providing new value, but is converting that issuer's obligation to pay the instrument into the value, thereby making the instrument negotiable. The instrument becomes the payment. At the point the instrument is issued for value, it is not a negotiable instrument. At that point, the definition of value in Article 1 applies. After it is received by the target, it becomes negotiable. At that point, the definition of value changes to fit Article 3. The instrument, being negotiable, can be enforced by either party depending on what the transferee does with it. If he just holds it or argues about it, the issuer, United States, is entitled to enforce the instrument. If he accepts acceptance for value, he is entitled to enforce the instrument. That is a personal choice. It is better to be a holder in due course of an instrument than the liable party on an instrument. A holder in due course is entitled to enforce the instrument. One can be a holder of an instrument, a hot potato, without being a holder in due course. An instrument issued for value is a hot potato to a holder. A holder has liability. A holder in due course has rights, but cannot acquire that position on an instrument issued and transferred for value unless he takes the instrument for value, as said in UCC 3-302 A2A below, and returns it for value. It is still a hot potato. To be a holder in due course, the holder must meet all the elements listed in UCC 3-302. UCC 3-302, holder in due course. A. Subject to subsection C of this section and subsection 3-106, subsection D, holder in due course means the holder of an instrument if 1. The instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity, and 2. The holder took the instrument for value in good faith without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to payment of another instrument issued as part of the same series. D. without notice that the instrument contains an unauthorized signature or has been altered. E, without notice of any claim to the instrument described in section UCC 3-306, and F, without notice that any party has a defense or claim in recoupment described in sections UCC 3-305, subsection A. Negotiability. An instrument is not necessarily negotiable when it is issued, and the one who is holding it is not necessarily a holder in due course. All of the 6 requirements listed in UCC 3-302A2 must be met for one to be a holder in due course. The first is that the instrument be taken for value. According to the Oklahoma case, UCC 3-303 says a holder takes for value when it acquires a security interest in the instrument otherwise than through a judicial proceeding. Make a note of this. It is the holder who acquires a security interest in the instrument. If he takes the instrument for value, it is not the issuer who has a security interest. It is the holder. The issuer has the liability. The holder can waive the security interest with a blank endorsement, or accept it with a qualified endorsement. With a qualified endorsement, the holder is accepting the security interest, not the liability. Judicial court orders can transfer rights and property, creating a security interest in the title to the subject property. But that is not how it works with an instrument that is issued for value. An order for a judicial court created security interest is not the type of instrument that a transferee would take for value, but an order for an executive court created security interest is a type of instrument that a transferee would take for value. United States courts are not judicial courts. They are territorial courts and were created through Article 1, Section 8, Clause 9 by the power granted to Congress to constitute tribunals inferior to the Supreme Court. Their orders do not result in security interest through judicial proceedings. A check is negotiable when it is transferred to a payee. It is a note because it is not the maker's promise to pay the payee. It is also an order to a third party, so it is a draft signed by a drawer. A named third party, the payer on a negotiable instrument, has a duty to pay it if he is a party to a pre-existing arrangement with the drawer to do so. On a normal check, a bank is the payer. The drawer is the party ordering the payment on the draft. The payee negotiates the check by endorsing it and presenting it to a bank for deposit. If the payee and the drawer bank at the same bank, the bank where the check is deposited can also be the payer. The payee is usually a holder in due course. If the check is lost, a person who finds it is not a holder in due course and is not entitled to enforce the instrument. The one who endorses it takes on the liability if the bank where it is deposited cannot collect on it. He has recourse against the drawer. A check is not an instrument that the payee would take for value, but the bank where it is deposited might take it for value in the event it believes there may be difficulty in collecting on it. If you endorse a check without recourse, you are giving notice that you do not agree to take on the liability, but you may not be able to convince a bank to accept it with that qualified endorsement. If you endorse a check with just your signature and present it to a bank for deposit, you are giving your rights as a holder in due course over to the bank. You are also agreeing to take on the liability for the tax on that instrument. An IOU is not negotiable because there is no third party. An IOU is a promise to pay and is signed by the maker. The holder of an IOU can only present it for collection to the maker. Other instruments that are notes, promissory notes, are not necessarily negotiable either. United States notes, promises, were originally negotiable because the holder could take them to any Federal Reserve Bank third party and redeem them for gold and silver. Federal Reserve notes are obligations of the United States that are not negotiable. They are promises to pay. They are obligations that are not redeemable. See 12 U.S.C. 411 as amended. Federal Reserve notes are considered to be a benefit U.S. citizens get to use within the United States. A promise can be value. Suffering can be value. A benefit can be consideration. Sufficient to support a simple contract. Using Federal Reserve notes is considered taking advantage of a benefit, consideration. In exchange for rights, the United States has to enforce the terms of a pre-existing citizenship contract, a pledge, that is the implied basis for its agents to issue bills, instruments to U.S. citizens, but they have to be issued for value. The term of the pledge are the hidden basis for issuing instruments for value. There's a difficult presumption that every U.S. citizen has made a pledge to the United States and its statutes. Other than the issuer's obligation to pay an instrument that is issued for value, there is no value in the instrument when it is issued. It is not negotiable when it is issued. It is seeking a negotiable instrument. An issuer has a defense for issuing instruments without consideration. If they are issued for value and a promise previously made by the transferee, U.S. citizen, is due and has not been performed, the payment on the the payment on the national debt is always due and has not been performed. If an employee of the United States transfers a bill instrument for value to a U.S. citizen, the man who represents him might recognize that the bill has been issued for value, so he can accept it for value and return it for value to close the account on behalf of the U.S. citizen. The U.S. citizen has a legal duty to pay the bill, and the man has a moral duty to close the account. He can close the account if he first accepts for value the bill that was issued for value. When he does that, he has provided sufficient consideration that is needed to balance the implied consideration that was provided by the issuer. It is like for like. It is like for like, or quid pro quo, essentially. This for that. You want this, I want that. You get this, I get that. He is actually providing the consideration for both sides of the transaction, i.e. the accrual bookkeeping system. The instrument that is issued for value is the debt side of an accrual account looking for the credit side. Everything is backwards. Usually you make a deposit, credit, to your checking account before you write a check, debit, against the account. You start with the credit and then you can authorize a debit by writing a check. In the commercial system used in the United States, the debit appears to come first and you have to supply the credit to make the deposit possible. The instrument is the credit and your endorsement makes it the debit. If you accept the credit for value and return it with a proper endorsement, the instrument balances the account. If you give it a blank endorsement, by just holding it, you have to send the issuer another instrument as the credit. To be safe, one who receives an instrument that has been issued for value has to get rid of it as soon as possible. Whoever is holding it is liable for it. It is a hot potato. If the holder fails to recognize that it was issued for value and gives it a blank endorsement, he has become the responsible party replacing the issuer. He becomes the issuer and transferor with the obligation, and the original issuer becomes the transferee. He has to supply the consideration to fund the instrument and close the account. He can do this by writing a check on an open bank account with sufficient funds and sending his check with the bill to the issuer. He can minimize or eliminate the liability by giving the instrument a qualified endorsement, acceptance for value, and giving notice that the one taking the instrument from him has no recourse against him if the instrument ends up being uncollectible. It is uncollectible until he gives it some value. It was issued for value, i.e. to get value, and it does get value when it is properly endorsed. The question is, who is entitled to enforce the instrument? The original transferor or the original transferee? This is a personal choice. When we return, we'll be talking about without recourse, proper endorsements.